we have some administrative meeting. You know that Honorable Chief Justice of India has been pleased to come here. So we have a administrative meeting. We got late for 10 minutes. Okay. In view of the above discussion, the second appeals being SAT SAT 5 2023 and SAT 7 2023 are dismissed on contest. No cost shall could record be returned along with a copy of this judgment. Next.
This and five. I have prayed for some pre-claim protection.
Yes, yes. So have you filed any application?
No, it's still the active version.
Conjoint?
The judgment has tested on certain legal grounds.
Yes. Or is it?
Take time. But till such time, the order of eviction needs to be state for its opposition.
Yes, where is the order?
You are at page 44.
Page 44.
May I give the background of the matter?
No, not required.
For the ordering portion would be at page 46, serial number 9 at the bottom.
Yes.
In view of the above findings, it is hereby held to the respondents are the unauthorized possession of land belonging to AAI located at number and according to tolerance of the past. The respondents are directed to vacate the said land and remove all unauthorized structures and instruments not belonging to the 15 days from the date of receipt of this order. Failure to comply with this order to result in the AAI taking necessary action, including forcible eviction in accordance with the provisions of AAI and other applicants law. The respondent shall be liable to pay for any costs or damages inflicted by AAI due to unauthorized occupation in the zone there. Schedule has been mentioned.
So he has a right to agitate this matter. The learned counsel, Yasun. The learned counsel.
But my objection may kindly be posted.
Yasun. Please come. The learned counsel, Mr. Joypal, has submitted that an eviction order was passed on 3/3/2025 by the eviction officer directing the appellants to vacate the suit land and remove all unauthorized structures, encroachments, or belongings within 15 days from the date of receipt of the order. In default, forcible eviction will be done in accordance with the provisions of Airport Authority of India Act and other applicable law. The learned counsel has submitted that if the said eviction order, if the operation of the said eviction order is not stayed, he will the appellant will suffer irreparable loss and injury. Stop. Para. The learned counsel appearing for the respondent has submitted that there are certain justified grounds for which the relevant eviction order was passed. He has, she has objection for granting stay of operation of the said order. Stop. Kara. I have considered the materials on record. It appears that by order dated 3/3/2025, the appellant has been directed to vacate the relevant suit land, and it further appears that the appellant has legal right to challenge the said order before the legal forum. And I find that if the impugned order is not stayed, there is every chance of causing irreparable loss to the appellant. Where, in view of the above, the impugned order dated, the operation of the impugned order dated 3/3/2025 passed in eviction case number 6
Yes.
of 2024 by the eviction officer, Airports Authority of India, Veer Savarkar International Airport, Sri Vijayapuram, Andaman and Nicobar Islands, is stayed until further order. Stop. You want to file any objection? The respondent is given liberty to file affidavit in opposition. Stop. This is the matter before the next available circuit. How many cases are there? So same.
Same date, same number.
Names may be different.
Yes, that's all. That's all.
Okay. Now I have asked him to show take instruction. Yes, what happened?
She was notification 1957.
Hmm.
Then it was amended on 1972. That is the final. That is annexed to the list.
1972. Why is that?
With the report.
এই রিপোর্টটা কালকে দেখেছিলাম তো, কোথায় গেল রিপোর্টটা? তো yes,
Notification 1972.
yes, 72.
So I am reading the amendments. First, after first paragraph, amendments. In the same notification as subsequently amended, amendment number 1. So we are concerned with amendment number 2. In clause D, in the opening paragraph, the following shall be added at the end, namely, and the area located between coordinates mentioned below in the eastern coast of Great Nicobar Island. And it was measured as a longitude, latitude, and next page is map is given. While you see the map, longitude 93, then thereafter 4. PAT, that is protection of agriculture excluded area under Great Nicobar. That is Campbell Bay and Banana or Banana. This part is excluded as per the first notification.
Just a minute. First notification means 1957.
1957.
So you are referring which paragraph?
I am referring the latest one, amended 1970.
Okay, now
Now the D. A, first page is A, B, C, D, last one.
yes.
The entire area comprised in and enclosed within the coastline of each of the following islands, but excluding the area comprising the airfield in Nicobar and the port of Calcutta and Nicobar. So what was the amendment? Proceed. D amendment was in the clause D, in the opening paragraph, the following shall be added. Opening paragraph. D is the entire area. The following shall be added at the end. At the end, name is given. The name of the place. Nicobar starting line. Name of the place. Nicobar starting. And thereafter, and the area located between the coordinates mentioned below in the eastern coast of Great Nicobar Islands. That Indra Point, that Campbell Bay, that is Great Nicobar. That is Great Nicobar. And report is supporting that part. Notification, next one is
According to him, he is a resident of that local area. And why? According to him.
According to charge sheet.
Yes.
I like to be according to charge sheet. No,
According to charge sheet.
Great Nicobar different island, one island. Some portion declared as a tribal area.
Yes.
In some portion like a Campbell, like a Karnikobar enter tribal area.
And the project is going on in that tribal area.
Permission required. Lordship,
So,
Campbell Bay, Nicobar tribal area. Lordship, in Karnikobar, government servants are staying there. Businessmen are staying there. But entering into Karnikobar, enter Karnikobar, title pass is required. So in Great Nicobar, some portion that is Indira Point declared as a tribal area. Lordship, if there is a no notification, still existing that is 1970 to 1957, that is declared Great Nicobar, some part of that island, Lordship, whether tribals are residing there or not.
here there is a mention in your report that there is a map showing that Indira Point is within the report. Further a copy of the map showing the above longitude and latitude is.
Lordship, it is decided on that manner, longitude, east, longitude, north.
Please hear my question then. Further, a copy of the map showing the above longitude and latitude is enclosed. And as per the above notification, the remaining part of Great Nicobar Island, including Indira Point, falls under Andaman and Nicobar Islands, protection of aboriginal tenants.
Sure.
So where is that map? I want to see.
Lordship. Next, last page, Lordship of the report.
But there is no map. Just
No map means Lordship, it is measured as a longitude. So it's required in report. Instead
so
of.
do you have map?
Map, I have.
No, referring this.
With the notification 1950, 70.
No, just see it as further a copy of the map is enclosed. Why is that map? I want to see. And enclosure has been stated that as above. So why is that map?
Because it is not. I have a copy.
Show us. Whether I can.
हाँ,
इसमें नहीं है. Pat excluded area under Great River. Is the Indira Point? It has.
name of place not mentioned as mentioned in the report.
It can be.
My lord, may retain it. I will show my lord. Indira Point is there. Indira Point is there, but it did not come within that longitude and latitude. I will show.
Yes.
Let my learned friend conclude.
Okay. So you are saying that it is within the this extra restricted area.
But see, my respect to submission is that longitude, latitude is measured as like that, not by name. Because some places there is no name, some places it is by north, south, like that it was mentioned. The question is, Lordship, entering in the tribal area, whether tribal that area is falls under restricted area or not. And this stage cannot be decided, Lordship.
Factual aspect.
Purely subject matter of the tribe.
Okay.
Purely subject matter of the tribe.
Yes.
My lord, first of all, my learned friend is arguing for the argument's sake. Admittedly, we all, the resident of Andaman Nicobar Island, we know that Campbell Bay is not a tribal area. We all know. But he is arguing, my lord, may first come to this notification which my learned friend relied. And the map, my lord. Notification says, my lord, if my lord sees the order of 22nd January 2024, there it has been reproduced, my lord. 22nd January. My lord,
Yes.
can you see the amendment which has been made? What if, my lord? Now, my lord, can you see the map which my learned friend cited? Now, my lord will find from the order. Longitude is 93.50 and 93.57. Now, my lord will get this this longitude in the inside map. My lord, can you see? It is on and above. Now, first, my lord, will see Indira Point 6.45. Second from the bottom 6.45. Got it, my lord?
6.45. Yes,
Indira Point. Now, my lord, can you see the order that longitude and latitude? This is not at all covered.
And 93 point.
That is on and above. That is 93 point. My lord will get at this where it is written PAT excluded area.
PAT means?
That is the prevention of.
Oh, sorry.
Protection of aboriginal tribe.
Now, my lord, can you see 93 is there? Got it, my lord?
PAT excluded area under that. That means in this point they can visit.
Yes.
Yes. No, no, my
Can
lord.
visit.
That is excluded,
No,
not
no, the
included.
following shall be added
Yes,
as part included. My learned friend, my lord may kindly see the amendment. The amendment, my lord may kindly see.
Hmm.
Now, my lord may kindly see latitude, 6.53, it starts to 7.2. Now, my lord, this is at 6.45. This is not incorporated in this amendment of 1972.
6.56 degrees. It is 6 degrees.
6.53, and this is at 6.45. Now, my lord may see, this is the amendment.
Here
made.
is 6 point, just a minute, not 7 degree. 70, what is 7 degree? 7,
This is at the top, my lord.
7 degree.
Yes,
7 degree 2.
yes. That is at the top.
Yes,
6, 7.
yes.
My lord, this amendment was introduced to incorporate the place which is being governed under the set 1956 7 regulation.
Hmm.
So this is not at all covered. Now, my lord may kindly see the order of this court of 22nd January 2024.
Yes.
Now, my lord may kindly come to the second page, my lord. Last 3 lines. The court has specifically given them the right to place it. The court said to that effect, the officer submitting, preparing the report would rely upon authorities to be notification, circular, orders, or any meteorological finding. So, my lord, what happened before the court? I have placed this 1957 and 1972. The court was convinced that no case is made out. When the court was about to pass an order quashing the proceeding, my learned friend seeks a time saying that there are further amendments, we will place that before the court. That point of time, the court has ordered that mere filing a report by the authority will not do. You have to place the notification or circular or order or any meteorological finding to that extent that this area is covered.
Hmm.
And admittedly, my learned friend has not filed any circular, any order, any notification or meteorological finding before this court. So the stand which I have taken and which they have taken on that day stands true. So under
Okay.
such circumstances, my lord, this is absolutely a
Absolutely
false
right.
case initiated against my client.
Yes, sir.
Yes, yes.
First, kindly come to the section 3. If the disputed arose regarding which area is the reserved or not, kindly come to the PAT regulation, protection of habitable. Kindly come to the section 3.
Why is that?
I have those.
But I do not have.
I am.
No, no, my lord, I have handed over my copy. my lord.
Section 3, subsection P. Clause 3. Section
Yes. Section 3.
3, Lord, kindly.
The chief commissioner may by details. If any question arises whether any area falls within the or without a reserved area, it shall be decided by the chief commissioner and his decision shall be final. So you could have filed this
Yes, my
report.
lord, in terms of the order of the court.
That matter that if dispute arose, when it will be decided during trial or see.
Okay. Okay.
During
Hey,
trial or see.
the learned counsels for the parties have concluded their submission. List the matter on 11th for order. Okay. I'm keeping this.
My lord, I have already handed over this. My book is lying before the court.
Hey, see, only one book is, yes. One book is there.
Yesterday I have handed over.
Yes. This book, no? Okay. So I shall hand over it to you. What দিয়ে দিন না? But keep this book, yeah? 11.
In this matter, my lord, there is a error apparent on the face of the record, my lord. What happened, my lord? I have taken out a discharge application
Yes.
before the London trial court.
Hmm.
While rejecting my prayer, my lord, there is an apparent error on the face of the record. So what I am on today, my lord, if my lord is convinced with my argument so far as there is an error apparent on the face of the record, the matter may be relegated back to the trial court, because if my lord may kindly come to page 70, my lord. This is pertaining to casting of a slab which was collapsed
Yes,
in
yes.
2008. My lord may kindly come to page number 71.
70.
70. The report of the expert.
Yes,
My lord may kindly see second paragraph.
yes.
Hence, from the above, it can be concluded that the structural drawing has not been followed. My lord may kindly have a note of this.
Yes.
Not been followed at all, due to which the possibility of structure failure cannot be ruled out.
Yes.
So, my lord, the report was that the structural drawing has not been followed. Now, my lord may kindly come to next page, page 71. Last three lines. This is the finding of the expert, my lord. He says the responsibility due to lack of supervision and non-adhering of drawing and specification needs to be fixed for. So, my lord, here also it is
So last 71.
71 last three line.
However, no the responsibility.
The responsibility due to lack of supervision and non-adhering of drawing and specification.
Needs to be fixed.
Yes, my lord. So, one of the ground was that non-adhering to the drawing and specification.
But lack of supervision is also
I am
there.
not on lack of supervision. What I am on, my lord, the court here, the finding is that they have not adhered to the drawing. Now, my lord, may kindly see the finding of the trial court on this issue at page 101.
Yes.
Page 101, my lord, sixth line from the bottom. He further submit that. This is the submission of the public prosecutor. I believe that he has not made this submission. It says that he further submit that from the inquiry report it revealed that there was structural defect as well as defect in structural drawing. This is nobody's case that there was a defect in structural drawing. The case is that they have not adhered to the structural drawing. Now, my lord, the finding of the court at 104, my lord may kindly see. I am not convinced, my lord, from that, from the bottom, my lord sees 15th line. The inquiry report of the expert, as well as general inquiry report clearly show that there was structural defects in drawing and engineering. So, my lord, this was the basis on the basis of which the court arrived to the finding that I am not entitled. Now, my lord, it is contrary to the record, my lord.
It is 71. Is it
Yes,
the charge sheet?
70 and 71.
Is it charge sheet or report?
This is the report of the expert, my lord.
Yes.
Who is an engineer under the anti-corruption unit.
It is final report. Yes.
Yes.
So what was their case?
Their case was that there was
non-adherence of drawings and specification.
Yes. Non-adherence of drawing and structural. Here the court arrived to the finding that the inquiry report of the expert, this report, as well as page 104. Madam.
Yes, I have seen that.
Yes, the inquiry report of the expert as well as general inquiry report clearly shows that there was structural defects in drawing and engineering. So this is an absolutely prima facie defect. And because of this, why I am saying, my lord, when the work was executed, I was transferring a year before that. Before that to some other place. The court said when the structural drawing was prepared, you were there. The drawing was defect, therefore you are also responsible. Work was not executed in my period. So, my lord, this the court went wrong. If this is corrected, I will be released, my lord, because
how? What is your suggestion? That why I shall relegate?
Relegate because, my lord, the case of the prosecution is that the concerned engineers did not adhere to the drawing and structural drawings. Court to be finding that as per the report of the expert, the drawing was not correct. Whereas that is not nobody's case, my lord. Page 104.
Yes.
My lord, see, this is error apparent on the face of the order, my lord. Page 104.
Yes.
If my lord sees, if this comes, my lord, because the work was executed in December 2008. I was transferred in July 2007. I was not there at all when the work was executed. But
no, it does not mean that you have the authority to supervise the work.
No, I was transferred.
No.
I was transferred, my lord, work taken place in.
That is a factual aspect that can be cited.
My lord,
But so far as this order is concerned, I find that he exercises jurisdiction in other
no, my
way.
lord, the court.
Structural defect that has not been mentioned anywhere.
The inquiry report of the expert as well as general inquiry report clearly shows that there was structural defect in drawing and engineering. That is nobody's case. If this goes, my lord, I will be discharged by the trial court because I was not there. This work was executed in the year 2008 December. I was transferred in 2007 July.
Whatever it may be, structural defect is not anybody's case. That is his
Nobody's
service.
case.
There was a total engineer's team. There was a total.
My lord, I am making a limited argument.
No. According to your prosecution case, there is a that the structural drawing has not been followed.
Yes.
That is the one thing.
Yes.
And it is also that due to lack of supervision and non-adherence of
Yes.
drawing and specification needs to be fixed for the delinquents. So far as this observation that there is a structural defect, it goes against the prosecution case.
Lordship, it is the observation made by the trial court, Lordship.
Not objection, this is the finding of the trial.
No.
Observation finding that supervision rejected, Lordship.
Yes.
You have to see the entire charge sheet that how she is beginning.
My lord, what I am on.
I am not on that. I am going to discharge you because I find that there is a.
My lord, what I am on, I am making a limited submission, my lord.
Yes.
This was an error apparent on the face of the record.
So,
If it is relegated back, my lord, I can pursue the court so far as
so I should ask the officer, magistrate to
reconsider the issue because this is falsely recorded, my lord. This is my submission. I am
not
going-
falsely, but it's a mistake.
My lord, kindly.
Mistake.
Not a mistake, my lord. This is error apparent on the face of the
Error
record.
apparent.
Because, my lord, that is nobody's case, my lord.
So in three cases, in three cases,
7 and 8.
I think another the same point.
Same.
So yes,
There's only on this, it was relegated back within a.
the learned counsel for the petitioner has submitted that there is an error apparent in the face of the record in the impugned order dated in the impugned order number 26 dated 21/11/2024 in special case number 01 of 2022 passed by the learned Chief Judicial learned Special Judge Corruption Act A and Islands Port Blair. Stop. The learned counsel has categorically has drawn the attention of this court to the final report furnished by ATE. What is full name? Anti-corruption. ATE.
Anti-corruption unit, engineer company.
ATE. Why?
SCU. Because
ATE.
in anti-corruption unit, there would be an expert engineer who would be posted there.
আচ্ছা এটা দেখে নাকি হ্যাঁ this was the final report কি বললাম হয়তো wherein it has been categorically observed by the said expert body that the structural drawing has not been the possibility of structural failure cannot be ruled out. Stop. The learned counsel has also pointed out the following observation of the said expert body. Quote, the responsibility due to lack of supervision and non-adherence of drawings and specification, needs to be fixed for the delinquents in this regard. Stop. In spite of such observation of the expert body, the learned court, while rejecting the prayer for discharge of the revisionist, has been pleased to hold in the following manner. বলে এখান থেকে করে দেবে, হ্যাঁ, and thereafter you erase marks. These marks, hence, 104. This one. But it appears that it has been submitted by the learned PP.
No, that is first part.
In the first part, it has been recorded.
No, but the second part is the finding of the court.
Finding of the court.
I find that.
So, yes. Okay. The according to learned counsel, the learned judge has made out a third case, since in the expert body report there is no such term structural defects in drawing, inverted comma quotation I'm doing. Stop. If the said an anomaly persists, comma, the appellant will suffer irreparable loss and injury. Stop. As such, the matter should be relegated to the learned trial court for fresh application of mind. Stop. Para, the learned counsel for the state opposes the submission of the learned counsel of the revisionist. According to him, the entire materials on record is to be considered, and that has been done by the learned special judge. Stop. Para, I have considered the materials on record. I find that in the report of the expert body, there is no whisper about the structural defects in drawing, as mentioned in the order of the learned special judge. However, as the matter is very serious and there is an error apparent on the face of the record, I think that the matter should be relegated to the learned special judge for fresh application of his judicial mind in accordance with law. Accordingly, the order dated 21/11/2024 is set aside. Stop. The learned special judge is requested to dispose of the relevant petition under section 227 of the CRPC filed by the accused persons, appraise without being influenced by any of the observation of this court. Stop. There. The CR or revision application is allowed on contest. No costs. Let a copy of this judgment or order, whatever it may be sent to the learned special judge. Designation, full designation, please give full designation. With a request to adjudicate, with a request to dispose of the relevant application within 2 months from the date of receipt of this order. তিনটেই হবে।
Both the same.
both the matters.
I am appealing this matter.
But I do not understand why this, no, not you. The respondent should not be served.
My lord, there, I have filed an execution case, the court said the respondent is to be served. I am aggrieved by the fact that the dates are being fixed after 4 months. The Supreme Court in new judgment I have, which I
আসুন লিখে দিন। The learned counsel,
said within 6 months, my lord. Let's
hey, why is the record? Give me the record. The learned counsel for the petitioner has submitted that the petitioner, being a decree holder, has filed an execution application, but unfortunately
was issued and the case was fixed on 21st of July.
কি বললাম ওখানটা বলুন। Being application being number, execution application being number
Yes. Number 13 of 2024.
13 of
2024.
2024 before
Before the civil judge senior division.
beginning, before the civil judge senior division. What is this? You are Pradeep Kumar Vishwas. এটা which case? কি ভুলভাল দিচ্ছেন আপনি?
Civil division, item 9.
9, item 9 দেবেন তো। You did not call. Number কত? 13 of 2024 of the just second. I've just I think which unfortunately delete. The decree holder is under an obligation to issue notice upon the judgment debtor as the decree was passed more than 2 years ago. Stop. The case was instituted on 12/3/2025 or
19th November 2024.
19th November 2024. Thereafter, hearing of the case was fixed on 18/12/2024 and thereafter 7/3/2025.
And now on.
Fine, full stop. On 7/3/2025, it appears that the learned executing court as stated above, has fixed the date on 21/7/2024 for steps by the decree holder. There, this the learned counsel for the petitioner has submitted. There is no reason for fixing a date after more than 4 months for taking steps by the decree holder. Stop. When the suit was filed,
My lord, suit was filed. Uh, 2010, my lord.
and decree was passed,
On 27 December 2019.
the learned counsel has also submitted that the relevant suit was filed in the year 2010 and a contested decree
My lord.
was passed in the year 2019. Stop. Therefore, the plaintiff of the petitioner has devoted has is unable to execute a relevant decree even after institution of a suit 15 years ago, almost 15 years ago. Stop. The learned counsel has also drawn the attention of this court to the recent judicial decision of the Honorable Apex Court in civil appeal numbers 3640-3642 of 2025 in support of his contention. What is your contention?
My contention, my lord, the Supreme Court had repeatedly said execution proceeding ought to be completed within a period of 6
The execution proceeding should be completed within 6 months. Why it has been? Because it is more than 78 pages.
My lord,
In which-
page 76 is the operative portion, my lord. 3 judgments were already also referred by the Honorable Supreme Court. Para 75. In view of the above, we direct all the High Court across the country to call for the necessary information from their respective judiciary as regard pendency of the execution petition.
I find merits in the submission of the learned counsel. The relevant paragraph of the Honorable Supreme Court may be quoted herein below. Observation as made in this above mentioned civil appeal. Okay, maybe the 75 টা লিখে দাও, হ্যাঁ? 75 টা পুরো 75. Okay. Stop. In view of the above, I find that this is a serious issue and the learned trial court, learned executing court should consider the direction of the Honorable Apex Court in this regard. Stop. The learned the decree holder. No, the civil revisional application stands allowed. Stop. The executing court, that is which court? Civil judge
Senior divisions or not?
is directed to prepone the date of hearing, that is prepone the date of hearing, date of taking steps or something like that. Prepone the date of taking steps from
21st July.
21st July 2025 to any other convenient date as the diary of the court permits. Stop. The order dated 7/3/2025 passed in other execution case number 13 of 2024 of Senior Judge Senior Division, Civil Judge Senior Division, Port Blair, is set aside. Stop. The decree holder is at liberty to file an appropriate petition before the learned trial court below, learned executing court below. Get a copy of this order sheet.
In a time frame of the disposal, that is what Supreme Court said.
No,
The execution proceeding ought to be disposed of within time frame. I am not saying that.
I have directed.
That,
I have directed to follow the.
my lord, may not specify otherwise, any period, my lord, because.
No,
Supreme Court
because the learned council will take time. The learned council will show that there is a bar council's regulation. I shall not. I shall not. You take. You are
Expediency,
taking.
at least, my lord.
That can be done. Duke. This is a situation. Our bar library has taken the resolution everywhere. Yes, that can be done. Expeditious. The learned trial court is the learned executing court is requested to dispose of the matter as expeditiously as he can in view of the judicial decisions of the honorable.
Yes.
That's sufficient.
Yes, definitely.
Even ignoring the bar resolution. Don't tell. Okay.
Obliged. Wait. Application for anticipatory. There are
Yes.
petitioners before your lordship. It's in a very peculiar sort of matter. The case is a case of murder. But before coming to the allegations matter, there is a lot of background which I need to place before you.
Who is for the, yeah, for the state. CD is available?
CD is available. And so far as the petitioners are concerned, petitioner number 1, Archana, and 2, Jaipal, they are husband and wife. Now, this petition number 1, Archana, she is one of 3 siblings. There is a brother called Alok, there is a sister called Rachna, and the third sister is Archana. Remember, this brother, Alok, was married to the deceased of this case.
So FIR has been, what? FIR has been enclosed.
FIR is annexed at page 132.
That's it. 132.
Right.
Please give me 1 minute. 32.
Right.
This is a formal FIR.
Formal FIR,
But what is-
includes the complaint portion at page 133.
How to go through this? Just a minute.
Right.
मैं अपने परिवार के साथ who is the complainant? Ramesh Ram.
Ramesh Ram, father of the deceased.
मैं अपने परिवार के साथ अपने निज मकान पर रहता हूँ तथा रिटायर्ड एग्रीकल्चर इंस्पेक्टर हूँ। हमारे घर में मैं और मेरा पत्नी कमला देवी और मेरा छोटी बेटी प्राइवेट में कुछ बिजनेस कर रही थी। फिलहाल वो हमारे साथ घर में ही रहती हैं। कल दिनांक 7 में करीब ये मेरे बेटी घर से बाहर गई और वापस समय करीब बजे का होगा और आई। फिर शाम को समय करीब पास उसने अपने कार के लेकर गई और समय करीब के आसपास मुझे स्थानीय लोगों ने आकर बताया कि मेरे घर के रास्ते में मेरी बेटी का लाश पड़ा हुआ और उसके कोई अनजान व्यक्ति जान से मार कर चला गया। मैं जाकर देखा उसके सर और हाथ में कोई धार धार वालों तरह से हमला किया है। मेरी बेटी की शादी से पहले आलोक नाम का व्यक्ति के जो करीब से अपने हस्बैंड आलोक से अलग रहती है। करीब आलोक राम ने अपने घर में सुसाइड कर लिया था। मेरे बेटी निशा रानी की कुत्ता में किसी का हाथ नहीं, ये नहीं बता सकता। यस।
Now, kindly see, there are three brothers and sisters. The brother is a man called Alok.
आलोक
The two sisters are Rachna and Archana.
ना
Archana is
आलोक नाम
number one.
जस्ट मिनट मेरे बेटी का शादी 5 साल पहले आलोक
Alok
नाम
is a word.
जो मर चुका।
So Alok's wife, Nisha, is the deceased in this case.
यस।
So Alok is married to Nisha. Archana is married to Jaipal. They are petitioner 1 and 2. And the third sister is Rachna. She is married to Praveen. So three brothers and sisters, all married. Now Nisha, who is married to Alok, is involved with Praveen.
Yes. Nisha is petitioner number
Nisha
one.
is deceased.
Yes, Nisha is the sister of petitioner number one.
Sister-in-law of petitioner number 1.
Sister-in-law of petitioner number 1. Yes, okay. Yes.
So Alok married to Nisha. Alok's sister Rachna married to Praveen. Nisha and Praveen were involved. Now dispute started between Nisha and Alok, husband wife. Praveen, Rachna, husband wife. Now those disputes were there. So far as Nisha and Alok are concerned, your lordship could see from annexure A1 onwards, I have given the entire history, page 38 onwards. Now, first of all, if your lordship sees, I will just explain this background because it is very necessary. So, page 38, first of all, they were married in 2018, Nisha and Alok. In 2021, some domestic disputes had started. She started making complaints against her mother-in-law Kamla, sister-in-law Archana and Rachna, and husband of sister-in-law Jaipal. From 2021, the disputes escalated at page 40.
No, yeah, the FIR does not name him. Okay.
No, I'm not on the FIR. This
Now, why you are apprehending arrest? That is
why?
the.
Because there have been property disputes going on in the family for a pretty long time. That is all these annexures. There are a total of 5 FIRs against each other, different family members. In this background, she had been fighting over the property. Alok suddenly was found dead.
When?
Alok's, so far as Alok is concerned, page 79 is the postmortem report, which will show his death occurred on 27 May 2024. Now, after his death on 27 May, police refused to lodge any FIR.
No, death is unnatural death or
Unnatural. Unnatural death. But police refused to lodge FIR. Kindly imagine a person is dead but no FIR. Now, on the 27th of May, he died. Postmortem is done on 29th of May. Then the mother went to the police with representations, page 81. Finally, after a gap of 2 weeks, FIR was chalked out on 7th of June 2024. So that is after a gap of 2 weeks. That FIR regarding Alok's death, that is at page 82. Now this FIR about Alok's death, it named
Kindly see page 82. It named three accused persons. Page 82, kindly see the last line first.
Yes, Nisha Rani.
Nisha Rani was the accused. Overleaf might not see. The second accused is Praveen. That is Rachna's husband.
Hmm. Yes.
And third accused was one Sneha. Case is under 306.
Hmm.
Although the complaint disclosed that the death was a suspicious death and the postmortem was not clear whether it is antemortem hanging or postmortem hanging. So in this situation, this FIR was lodged under 306 against Nisha. Alok is dead and gone. Now after this, dispute started about the property. Nisha went to the authorities and said, kindly mutate all the properties in mine. Meanwhile, Praveen, who was also having dispute with his wife, was having dispute over huge properties involving hotels, resorts, crores of money involved. In this background, they came up before this High Court, Nisha, that mutate my name in all the records. In that writ petition, when the hearing was going on, why not we find that order at page 88? Two writ petitions are there. The orders are at page 88 and page 100. So in the course of hearing, where she was claiming that all of Alok's property must go to her as a sole heir, these two petitioners, Archana Jaipal and the mother of Alok, they produced a
What do you say?
will
Will.
of Alok. A registered will of Alok that no, property must go to the petitioner number one in this case, Archana. Now over that, this court said all these matters have to be decided in the appropriate forum, you go there. So we went there and all the properties were mutated in my name.
Hmm.
Then she lodged a fourth FIR, Nisha.
Hmm.
The fourth FIR that is lodged is saying all the bills are false, everything is fake, etc. etc. Now Archana and Jaipal, they are residing at Tamil Nadu. You also could get from the cost title, their permanent address is at Tamil Nadu, but of course Archana is a girl of Portland or permanent residence is here. So they come in. Now in this background, with all these disputes and FIRs, suddenly Nisha is found in.
So Nisha is was unable to make his fifth FIR.
Now
So
the
as she is,
the fifth FIR
she
is
has been
about
filing false complaints against all of you.
whatever it is, now the fifth FIR is there. It is about her, so it is not by her. Now she is found dead with serious injuries, brutal murder, no doubt.
The circumstantial evidence.
Circumstantial evidence is what
Nobody saw.
nobody saw. Now
I have to consult
there are
this.
10 accused persons, my lord. 10 accused. 6 contract killers, 1 person in whose house they stayed, and family members. The allegation is you had so many disputes and property and issues, and you were accused by her, so you are involved. You have got some connection. Now they are taking out CDR, no details with regard to me. They are taking out bank records saying you people through your family members and your employees, you finance these contract killers, 5,000 paid, 1,000 paid, 500 paid. No clear material. Now charge sheet has been submitted. We have all along been ready to cooperate. We are living at Madras. They are saying you fled from Andamans. We don't even stay in Andamans. Now in this background, my lord, we have been ready to cooperate with this investigation from beginning. Charge sheet is submitted, investigation is complete. Contract killers are all in custody. Now they want me to go in custody. Now why I filed this
So
application?
first time you anticipated.
First time. Why I filed that tender question? Because we came to know that the state approached the learned CJ saying these people have fled away from Andaman Islands. Though we don't reside here, CJM issued warrant of arrest.
Oh,
Now we have no connection, nothing. The allegation is that because there were disputes, we are the financiers of the contract killers, for which they are relying on some bank statement, they are relying on some phone record, none of which are mine.
so your phone call with the contract clears.
No, not my phone call. My
Then-
brother has spoken to someone in Andaman who came on a visit to Andaman. My nephew came to Andaman sometime. He was on the same flight as the contract killer.
then one contract killer has received 5,000 rupees from someone in Tamil Nadu, because I am a man of Tamil
How
Nadu.
many persons are absconding? How many?
As of now, there are three, as I understand, the family members, they are describing as absconding.
So you did not appear or they did not try to,
No notice, nothing.
nothing. So us.
Suddenly, my lord, not available water.
Other case, 120 B is there, 34 documentation, 4, 5, 6 people have been entered as a contract giver, 30 lakhs rupees was contracted. All the evidence within the charge sheet. All evidence within charge, how they have conspired each other. What was the enmity? What was the motive and intention of this petitioner? All evidence within the record. Supplementary charge sheet has to be submitted. And regarding other transaction.
Now show us.
Lordship.
Ah,
Have you completed?
My lord, my only humble submission is this. With the greatest of respect to all concerned, every time a charge sheet is submitted here, police makes up its own theories. My only respectful submission to this court is this: whatever document is relied on, whether it is bank detail or call record, my lord will kindly say whether my name is there or not. That's all. If there is no connection, I am 100% confident.
Yes, tell us, Mr. Kaur. It's a case of circumstantial evidence. Now how the chain will be,
Lordship, first thing, Lordship, at this stage, the case depends on a circumstantial evidence that cannot be decided at this stage first, because other 7 accused persons who are arrested on the basis of the direct evidence. Some witnesses have seen CCTV camera showing the murder of that victim girl. All the witnesses have been examined.
that contract killers are murdering.
See everything, DIP parade was done, contact killer, what has, they have, how they, the victim was assaulted by a sharp weapon. Now question in respect of these two petitions, what was the primary role of this?
Exactly.
Intention and the motive came from this side, this petitioner solution. Why contact killer came from Tamil Nadu? They don't know Hindi languages. All are South Indian Tamilian. They were engaged by these two petitioners. That 120B, why they have been engaged? Come to
How
charge
the
sheet.
engagement was done? How the
Charge sheet,
engagement?
kindly come to the charge sheet. Charge sheet, I may be allowed to read, Lordship.
Yes, what
Charge
is the
sheet
charge?
not within the record, Lordship. They are not filed. Even though
Oh.
case have been charged.
Okay, tell us.
Lordship.
My lord, just on that route, we have filed the Bagalakama and applied the subsequent concrete and notified you. We have not yet finished.
For the charge sheet, Lordship. In the starting shop, important first part. In respect of these two petitioners, I am not arguing on the point that other 7 accused persons, that is based on a direct evidence. In custodial intervention of this culprit, that is contract killer, they all the accused person had confessed. All the accused persons who were arrested, they confessed.
Confess before whom? Judicial magistrate?
No, lastly,
Then-
before a police. Of course, that is not admissible. Of course, that is not admissible. But for linking the investigation, thereafter, bank transaction links. First, 15 December 2024, 50,000 transfer from Archana.
No.
From Archana.
Let them show.
Lordship, from
I will
Archana.
show, I will see.
My lord.
Lordship, from Archana, that is 15 December 24, on 17 December 24, 22 December 24. This amount was transferred to Chinnadurai. Chinnadurai was the brother of the Jaipal, one of the petitioner.
He'll take instruction and then submit.
Lordship, many, just, then from
Now I am
Chinnadurai.
giving you 2 minutes time, 3 minutes. Please,
No, only
answer,
that
no
part.
problem. I want to know.
Only 1 second, Lord. From Chinnadurai, Rahul Prasad.
Hmm.
He is the accused of that arrested person. Chinnadurai is the brother of the Jaipa. Money have been transferred from the wife, that is Archana, petitioner hearing, to Chinnadurai, brother of the Jaipa. From Chinnadurai, Rahul Prasad. What was the amount total? 15 December, 25,000, 15 December, 50,000, on 22 December, 40,000, thereafter 5,000, then via 22 lakhs via CDM Roy Court, Rahul Prasad Indian Overseas Bank Account.
22 lakhs.
20. 2 lakhs, total 2 lakhs. First, contract was for 30 lakhs. It is a bank transaction details first. It is a bank transaction details. First, the motive and intention, my learned friend already submitted how it was happened. So prosecution tried to establish the motive and intention on side of these two petitioners because they are the relative, the deceased husband. Alokram committed suicide, lordship. Alokram, husband of the deceased, committed suicide.
Hmm.
Then thereafter what happened? This Archana applied for mutation on the basis of false doing.
Hologram is a brother of Archana.
Archana
Yes.
and Alokram, two sisters. Archana.
Now,
Archana.
according to him, that the hologram after death of hologram, some FIR was lodged after 2 weeks.
Lordship, kindly see
If that is the suicide, how?
Lord, committed suicide, lordship. Read petition file. What purpose? Kindly see. My learned friend said for mutation of the entire. No. Kindly see the order for correction of the death certificate of hologram. Totally wrong submission.
I am
Read
very,
petition.
very sorry, my
No.
other friend has not. No, I don't like being told I'm making wrong submissions.
No, lordship.
There were two writ petitions, there are two orders annexed.
Yes, first order have read out for
Do not
correction
say
of
I'm
the
making
death
a wrong
certificate.
submission.
Lordship, for correction of a death certificate. Then read petition for correction of death certificate of the husband, that is hologram of the deceased.
So
Thereafter, what happened? False will was produced by whom? Archana, file mutation application before the Tahsildar concerned. Lordship, kindly hear me for a moment.
now I'm hearing you.
Dear Lordship, mutation when the parties concerned objector came, the deceased Nisha came to know that mutation application was filed by the Archana. Who is the beneficiary? Who is the beneficiary of that will, Lordship?
Hmm.
Even a Nisha, the deceased, filed objection before the Tahsildar that no, Alokram, when he was committed suicide, there was some disputes, domestic disputes between Alokram and the deceased.
Hmm.
But she is a legally wedded wife. 498A case was pending against these two petitioners, including Alokram also,
Hmm.
who was filed, Nisha deceased. What happened thereafter? That will was sent to the GQD by the private GQD expert opinion. The report has came, Lordship. Kindly see, report has came that no, the signed signature of hologram is not matching with other documents. It was a totally false document, will. And
No.
who has filed application, Lordship? Archana.
Now my question is, the investigation is complete. Then what is the need for?
Warrant already issued by the Supreme Court.
Hmm.
Let them surrender, Lordship. Why 120 being gravity of the offense? Kindly see. In the evening, usually murder a lady. And by the contact killer, Lordship, kindly see. They have been engaged from the Tamil Nadu. They don't know the Hindi language. That one's confessional statement was recorded by a translator.
How we have arrested contact killers from Andaman or Tamil Nadu?
No, Lordship. First, 2 to 3 accused arrested, 4 accused absconded, entered into the deep jungle and concealed there. After 2 to 3 days, they came out. Police got information, then arrested. Flight tickets, how they can, everything within the record, charge sheet. Flight tickets, everything within the record. It was, kindly see, it is in the open place at Bhatubasti, in the front of the house of the deceased. Motive, intention clearly established at this stage, time of the 120B, disappearance of the evidence, 201, 302 IPC, and kindly see the PM report. how many injuries she has sustained. Kindly go through the entire charge sheet. Multiple injury, badly,
City.
Lordship. Moreover, Lordship, at this stage, the more important part is Lordship, kindly appreciate it, but non-bailable warrant was issued, charge sheet filed, that they were absconding. They are resident of Andaman. They absconded, including the staffs of this petitioner. Total 3% absconding. Who was the third person? They are staff who has deposited money in the ATM. That part has to be investigated by the investigation office. Lordship, warrant pending, some notice, lookout notice already issued. If a non-bailable warrant is pending issued by the CGM court, Lordship, let them surrender. Next process is let them surrender. Purpose of fair custodial interrogation very much required. Lordship knows 120
Custodial interrogation.
Lordship anticipatory bail. Now warrant pending. Either
The charge sheet has been submitted against them.
Lordship, charge sheet submitted even though some parties left. Kindly see, I have mentioned in my charge sheet. Some part
What is
important.
charge sheet?
I am giving the entire charge sheet.
Intercity.
Lordship, warrant pending, Lordship. They should surrender or cooperate with the indication after it.
Corporate, I'm saying.
Lordship, since the restriction of the effort they are absconding, including 3%. They escaped from this island. When got information effort shut out, 120B, 201. Kindly go through the entire charge sheet. Ample evidence have been collected by the court. Isolated place on Lordship Andaman, a small island, peaceful island. Somebody has been engaged by this two petitioner, motive, intention already prima facie proved in the charge sheet from the face of the charge sheet.
The charge sheet has been handed up to your lordship.
Yes, sir, maybe.
But kindly see one thing in
Oh,
the
yeah,
charge sheet.
my page numbers of charge sheet.
First, I black teacher.
Oh, flagging.
Page
But
number,
kindly see the charge sheet.
Charge
These
sheet,
two
yes,
accused. What is their permanent address as per charge
first
sheet?
question is the charge sheet starting.
Whether it is Andamans or it is Tamil Nadu. The learned friend is saying resident of Andaman spread away. Kindly see charge sheet, Jaipal Dhanakoti and Archana Dhanakoti. What is the address given? Because they are resident of a place called Krishnagiri in Tamil Nadu. Not at all Andamans.
And she has her father's house here.
She is a daughter of the soil.
Yes.
Order was passed for the
But they are not fled away from here. They are married and residing in Tamil Nadu for many years. In the charge sheet, they will probably be accused 8 and 9.
Why is the CDR? Why is the phone calls?
CDR in respect of all the accused, arrested accused person.
Accused, arrested, accused, contract.
Now, that means
Repeat yet to be.
contract killers are in touch with the accused persons, the present petitioners. According to you, please. According to you, they are calling the contact killers, everything. The present petitioner or her relatives, whatever. Where is that material?
That has been sent to the CFS Lordship, that CDR, everything. Sent to the CFS, Central Forensic.
So that has not been
No,
returned.
that has to be supplementary affidavit
Oh.
filed.
Okay.
Within 90 days,
So
the charge sheet filed.
why is the letter? Why is the letter sending the CDR to the? Why is that?
Can I show us?
So
All the.
okay, I'm trying to help you also. Arrested accused receiving money from Joypal's employee. CDR is here. Sir, you are saying that CDR is sent to the. No, I don't. Maybe the bank statement. Sorry, I'm extremely sorry. The bank statement. Why is that you have sent this CDR to? Joypal. Joypal is sending money. Joypal is sending money to the contract killers,
Sir,
not Archana.
Through Archana, Lordship.
Through Archana means?
Lordship, Jayapal. UPI transaction, Lordship.
Hmm?
UPI transaction and that phone is the custody of Jayapal. Jayapal sent to the Archana while that part is left. Supplementary charge sheet yet to be filed. That is mentioned in the paragraph of the charge sheet. What phone has been sent to the chief officer. After getting that report, the police will file a supplementary charge sheet. Lordship.
Just was that that you have sought the assistance of what is that question?
Forwarding note in the case diary written by Larry. This part will be seen. Forwarding note are in the case diary. It is from the charge sheet. That's which mobile phone.
This is mobile phone.
Have not been arrested. How could my mobile phone be revoked?
So, list of mobile phones sent for mobile forensics. Vivo phone, Hero Shakti. There's the accused persons who were arrested. I think.
Contracted.
Maybe. List of images, videos, article.
Not difficult, Your Honor. Where is the connection with me?
So that mobile phone of these absconding accused not never seized. How seized? They were not arrested.
No.
That of Rahul Prasad and other accused person.
Then how you are saying that there is a CDR between the present petitioners and the contract killers?
The CDR in between the other contract killers.
Between contract killer
Yes,
interstate.
contract killer, that CDR is there and supplementary.
Then
Lordship, that part is left. That is the important.
that is important between for them. But how? If you want to take time, please, no problem. I am here at least 2 days.
Lordship,
I want
Maximum.
I want to know from you that is there any phone call between the present petitioners and the contract killers or not? Whether
in this charge sheet, please.
Hmm?
Lordship, maximum WhatsApp call, online call, yes. Maximum WhatsApp, that is forensic report has to be.
you know, though it is true that WhatsApp call cannot be, that is encrypted, no problem. But WhatsApp call can be.
Lordship, not.
Whether
The case is based only on that.
I want to know from you that you are saying that there is a relation between the contract killers, engagement of contract killers by the present petitioners. There was some material that there is a bank transaction, you said.
Bank transaction.
Some bank transaction maybe there.
Jayapal to Archana, then Archana to brother of Jayapal, then it was reached to the Rahul Prasad.
So you there is a bank
Immediate.
transaction between yourself and the
I'll clarify that.
yes.
Archana,
Just-
Jayapal,
just-
and Jayapal's.
Right.
Archana,
Please
Jayapal,
here.
and Jayapal's brother.
Hmm.
They are all engaged in a common business. They have schools and they're running colleges in Tamil Nadu. These are monies which are transmitted from husband to wife to the other managers and employees of the schools.
No. They are saying there is a allegation. Please listen to me. This is their allegation that you or your relative transferred fund to these contract killers who are seen.
No single document. Let them.
You are saying, no?
Rahul Prasad.
Archana, he is saying
Rahul Prasad.
Archana
As per the
transfer
chart,
to
Rahul
Jayapal.
Prasad. 2 lakhs.
Jayapal transfer to Archana. Husband wife transferring to each other.
No problem. No
So
problem.
that is only his submission. Archana and Jayapal.
You take instruction properly, sir.
After murder also 5,000 saved
From who?
to Rahul Prasad.
Who is Rahul Prasad?
Rahul Prasad is contract killer. He is saying Chinnaduri.
Chinnaduri is brother of the Jayapal.
Yes, and he's not even accused in this case. Kindly see the charge sheet.
From Chinnadurai to Rahul Prasad, after murder also 40,000.
Chinnadurai.
Chinnadurai is the brother of Jayapal.
So this is an organized crime.
Organized
This
crime.
is an organized crime. They will not leave a clue. So why your brother is? I want to know from you why your brother is transferring fund to a contract killer.
Jayapal, brother Chinnadurai, they are saying. First of all, Chinnadurai is not an accused.
Yes,
Number
yes,
one. So if he is part of the chain, then he should have been an accused.
exactly.
Chinnadurai is not an accused. There is no whisper about Chinnadurai. Number one.
Hmm.
Number two, Chinnadurai has transferred to Rahul Prasad. Let them show from the documents A. B. who my brother is dealing with, what he has dealt with,
Hmm.
they have to establish a link.
Yes, that is true.
So my brother and I, we are businessmen.
Yes.
We can transfer to each other. Archana can transfer to me, husband, wife. How this is a.
Why Chinnadure has not made an accused?
Lordship, if there is a transaction chain, because we are emphasizing Rahul Prasad, Jayapal.
And Archana has paid me fees also.
Chain, Lordship,
And I accused.
Lordship, doesn't mean that Chinnadure conspired. He was a part of the organized crime.
No, there has to be
Jayapal transfer
something
money to
more.
his wife, Lordship. Jayapal transfer money to his wife,
Yes.
wife transfer to the Chinnadure brother of Jayapal. Then Chinnadure, his own instruction might be. Jayapal said, wife said, Rahul
Maybe
Prasad.
there is no maybe.
No, I have flagged it. Bank transaction, I have flagged it.
Hmm.
Why Rahul Prasad in business?
Hmm.
In business, why Rahul Prasad? Cash deposit was done by one staff of these two. That is, part is also late, one staff.
Which
And
staff?
how Joypal is involved? Petitioner number 2. Then
Jaypal and Archana. From
Mr.
entire
Jaypal is getting
transaction from
no,
Jaypal.
Mr.
He-
Jayapal is getting worried.
no, he is my officer. I am always
He's
for.
saying,
I am
from
always-
Jayapal, I'm from Jayapal.
I am always here for protecting our Joypal. Okay, please.
If Archana Academy has some education business, why all the money transact came from Jaypal account SDPF?
They're both running the business.
From Jaypal to Archana to Chinnadure handed money Rahul Prasad. Through UPI, I have tapped his back transaction.
Now you did not treat him Chinnadure as an accused.
Now they will make supplementary charge sheet after I made this submission.
Why? At this stage,
I made this
I am
submission,
trying-
tomorrow they will
I
make
am trying to
supplementary.
satisfy Lordship. I am trying to. Suppose there is a 12% transaction. Why Jaypal Archana? Motive intention is beginning in respect of landed property. Kindly see Lordship. Why after GQD of that will, when the objector file objection that is deceased before the Tahsildar Calcutta, for that is an FIR chopped out. Can you appreciate this particular? For forgery, first FIR have been chopped out against whom? Archana.
Hmm.
And on the date of FIR, then just after 8 days, murder taken place, Lordship. Just after 8 days, so many things had to be come to a proper interrogation and investigation. When the FIR was, can you appreciate? When the FIR was, just after 8 days, she has been murdered. When the FIR have been chopped against this person, Archana. Just after 7 to 8 days, the deceased was.
Just consider a hypothetical situation number.
Lordship, my
We
work
are
is
being paid
submission.
fees through UPI by Archana.
Lordship,
We have
Lordship,
appeared, we have shown that will.
Lordship,
Will is in our possession.
Lordship,
By the logic of my learned friend, this is enough circumstantial evidence.
Lordship, in all depends on circumstantial cases. Chain, corroborative evidence, direct, indirect, subject matter of trial. Question is,
Right, we will face the trial.
just a minute, let me finish. Lordship, some part is late. I cannot disclose at this stage, but some investigation is required. I have mentioned in my charge. Mobile phone of these two persons. Why they have been escaped from this island?
We will
Just from the
come
restaurant.
and hand over mobile phone tomorrow.
First,
and
legal
cooperate.
point is arrest warrant already issued by the city.
So,
Warrant, non-available warrant already issued against these two accused persons. Police went Tamil Nadu on the address given in the charge sheet, not found. Not found, Lordship. Not only escaped from this island, escaped from Tamil Nadu trying to escape. Lordship, what
In
is
a cognizable case, whether warrant is required.
what happened?
The
Charge sheet-
police could have arrested them
Lordship, they were
as soon as the allegation was leveled against
Lordship,
them.
in respect of cognizable request, police has the power to arrest.
Yes.
Difficulty see, policy. FIR registered, investigation started, investigation maximum portion completed. During investigation, all the accused persons have been arrested. These two accused, including that staff of these two petitioners, also absconding from this island. Total 3 persons have been absconding. Finally, anticipatory bail, Lordship. Not
Yeah,
required, the
absolutely.
warrant should be issued. Lookout notice already given.
The learned counsel for the petitioner has submitted
At this stage of the island, CS
That-
oppose the bail.
Petitioners have been falsely implicated in this case. There is no material showing that the petitioners have engaged the contract killers who allegedly murdered the victim lady. Stop. There is no CDR between call details report between the present petitioners and the arrested accused persons. Stop. There was no direct bank. There is no direct bank transaction between the present petitioners and the contract killers who are already arrested. Stop. The petitioners will cooperate the investigating authority if they are enlarged, if they are granted anticipatory bail. Stop. It is not correct that the petitioner number 1 and petitioner number 2 absconded from A and I, since the petitioner number 1 married the petitioner number 2 and our matrimonial home is at Tamil Nadu. Stop. As the investigation is complete, there is no need for custodial detention of the petitioners, and they will cooperate with the investigating authority if their prayer for anticipatory bail is allowed on condition that may be put by the learned court. Stop. Better. The learned counsel for the state opposes the prayer for bail vehemently. According to him, there are sufficient incriminating materials against both the accused persons, both the petitioners, since the bank transaction was made by one Cherian or Chinna Durai with the contract killers at the instruction of the present petitioners. Stop. The all detailed reports, all details found in the mobile phones of the contract killers were sent to forensic laboratory for report, and after getting the said report, the investigating authority will submit supplementary charge sheet. Stop. The petitioners had eliminated the victim lady after engaging contract killers who murdered the victim lady in a gruesome manner, and the materials on record are sufficient to show the involvement of the present petitioners along with others. Stop. If the petitioners are granted anticipatory bail, the prosecution will suffer a lot. Stop. There are chances for absconsion since they were not apprehended by the concerned police personnel, and accordingly non-bailable warrant of arrests are pending against both of them. Stop. The learned counsel for the state has also drawn the attention of this court to the relevant portion of the bank transaction details, wherefrom it is found that the brother-in-law of the petitioner number 1 and brother of petitioner number 2, petitioner number 2, that is Mr. কি নামটা বললো? চিন্না দুরাই, bank transaction details, bank details, therefrom it is found that the brother-in-law of the petitioner number 1 and the brother of the petitioner number 2, that is Mr. Chinna, was taken place indirectly to keep the involvement of the petitioner in the matrix. Involvement of the petitioner under matrix. Stop. Para. I have considered the materials on record. It appears that the investigation is complete and there are sufficient incriminating materials against the present petition. It is also true. It is also true that mobile phones of the present petitioners are still in the possession, are still in their possession, and the concerned IO did not have the opportunity to collect those mobile phones. From the record, it is found that the entire case is based on circumstantial evidence. Stop. It is further true that there is no direct bank transaction showing that the present petitioner had transferred fund to the contract killers, though there are sufficient materials showing that one of their relatives had transferred certain funds to the accused persons who are in the custody. Stop. The record also shows that there was an enmity between the victim lady and the present petitioner number 1 over some properties. Stop. As the investigation is complete, I think that there no fruitful purpose would be served by keeping them in custody. Stop. Considering all the aspects, I allow the prayer for anticipatory bail of the petitioners on certain conditions. The petitioner shall, in the event of arrest, the petitioner shall be enlarged on bond of rupees 1 lakh each, subject to the satisfaction of the arresting officer, and also on condition that the petitioners shall remain within the jurisdiction of Andaman police station, or what is police station?
Offense, place of offense, yes, Pahargaon.
So Aberdeen police station, or what is the
Pahargaon.
Pahargarh police station?
Their residence is in Aberdeen, my God, they will stay within the jurisdiction of Aberdeen and Farnham, both places.
Okay, remain in the island, both the petitions,
Right.
and the petitioner number 2 shall meet the IO twice in a week until further order. Stop. They shall comply with the conditions as laid down in section 482 of 2 of BNSS. Stop. In the event of failure on their part to comply with any of the conditions, comma, the anticipatory bail granted to them shall stand cancelled. Okay, that's all. Anything else you want to add? Any?
Both the petitioner, because something has to be done. Both the petition will be directed to make it done.
Ayo. No, if you want a lady police constable or something, he shall meet.
She shall meet, but.
No.
Inspector
She cannot be directed to appear before police station. A lady cannot be directed to appear before police. There's a law.
I can suggest something which will help my learned friend. Within 15 days, they will surrender and they will appear before the police voluntarily.
Immediately, within 7 days, not 15 days. Otherwise, 3 days.
7 days.
7 days, within 7 days. Within 7 days, and
Surrender before the CJ and they will appear before.
yes. Not, I think, now the warrant arrest has been issued.
That's why they have to surrender before the CJ.
Surrender, subject to the satisfaction of. I have stated that subject to the satisfaction of arresting officer, subject to the satisfaction of
CJM force.
CGM port player. CGM port player. Subject to on executing a bond of rupees 1 lakh with 2 CODTs of rupees 50,000 each, out of which one must be local, subject to the satisfaction of CGM port player, and also on condition that then the petitioner number 2 shall meet and everything. That's all. Within 7 days. Within 7 days.
Appear before CJ.
Okay, that's all. Any?
Cooperate with their.
Yes, both the petitioners should cooperate. So you must be grateful to the court. That you did not. Mr. Kumar is helping you.
Mr. Kumar is giving me a different thing which I had not thought. That
Yes,
warrant
yes,
of arrest will have to be recalled.
Huh?
That warrant of arrest.
That has to be. Should cooperate with the IO. Stop. Sobar শেষে the warrant of arrest issued against the petitioners is hereby recalled. But I did not issue the.
No.
But I cannot recall.
Called by the CJ.
The CGM court there is requested. So after appearance, not before. The learned CGM court there is requested to. Na eta এইভাবে লিখতে হবে. On their surrender before the learned court of Chief Judicial Magistrate South. He shall the learned Chief Judicial Magistrate shall recall the recall the warrant of arrest as issued by him. That's all.
We are always grateful to you.
Okay.
CDP.
CDP did. Ah, and this for the other side.
Lordship, I extend this over to appear for the opposite party. Because I'm the council appearing for the opposite party.
I don't understand. I don't admit it. They don't have the right of honor.
If I do not admit them, his case will go.
Lordship, first.
You will understand what he has said. Yes,
They want to appear.
yes, why not? The learned counsel, sorry, I have to admit. What is the case?
There was a diverse case filed by the respondent. Wherein I have used my written statement and.
So the matrimonial.
Subsequently, I have taken out an application for amendment under order 6/17. That was rejected by the
Nee. Who is that?
Your worship, item number 12 has to be placed in the next circuit.
Okay, at per request of the learned learned counsel of the petitioner, place the matter before the next available circuit for hearing.
But I have a respondent.
The respondent is also represented. Next,
Okay,
Your worship would remember this is that air conditioner.
yes, what is the other side?
And for the respondent, Mother. But I just want to say that we have carried out this agreement with the persons which we have.
What is this?
I was L1, your worship, what to do?
They will be retender.
The above subject was due to administrative reason already.
I didn't know that. After
So-
I-
The learned counsel.
Becomes infrastructure.
The learned counsel, Mr. Divesh Trivedi, has submitted that the relevant tender
Yes, your worship.
tender process has been cancelled due to administrative reason. Stop. He has submitted one communication between the concerned persons, concerned parties. Stop. Let it be kept with the record. In view of the above, the instant writ petition has become infructuous and is accordingly disposed of.
Same order in
Same
the
in the second. one.
Second.
I didn't
Second.
put the-
item number 14.
13, 14 same, হ্যাঁ? Okay. But দুটোতে আলাদা আলাদা করে একটা করে রেখেছে, একটা ওটা দেবেন, একটা এতে দেবেন, ঠিক আছে? এটা একটা রাখবেন এই চিঠিটা, ওটাতে আরেকটা চিঠি রাখবেন। হয়ে গেল, ডিসপোজাল হয়ে গেল। নেক্সট,
Please, your chief of the inside.
অমিত কুমার বিশ্বাস, এটা কি হয়েছে? Yes, Mr. বিশ্বাস, what is your এটা কে আছেন? সুমিত, মিস্টার সুমিত কর্মকার is not. So why is your medical certificate?
স্যার মেডিকেল সার্টিফিকেট আমি পাঠিয়েছি স্যার, ওখানে মেল করেছিলাম এখান থেকে সার্টিফিকেট, বাকি রেসিডেন্ট সার্টিফিকেট, মেডিকেল সার্টিফিকেট সারা আছে
আর কাকে পাঠিয়েছিলেন?
স্যার। রেজিস্টার কো এখান থেকে আমি মেল করেছিলাম স্যার।
এই রেজিস্টারকে মেল করেছিল বলছেন, দেখো ইন পার্সন করছে। আচ্ছা, এটা রাকেশ কুমার না কে ছিল না? ওটা বলুন তো। আচ্ছা আচ্ছা, এগুলো দিয়ে না। The learned counsel for the state is present. So what is আপনার কি প্রার্থনা, কি আপনি কি চাইছেন?
স্যার আমি এই চাই যে স্যার আমার সাথে কোনো ন্যায় হোক স্যার, কারণ কি আমার সাথে যা মানে ঘটনা হয়েছে স্যার, আমার খুব দুঃখ তো মানে পূরণ স্যার। আমার ঘটনার জন্য স্যার আমার পরিবারের পুরো ক্ষতি হয়েছে স্যার। কারণ কি স্যার, আমাকে পুরো প্ল্যান করে এই এসএচও আদিত্য নারায়ণ স্যার এখান থেকে আমাকে ঘর থেকে মিথ্যে কথা বলে স্যার নিয়ে গিয়েছে। নিয়ে যায় স্যার, 2 দিন রেখেছে আমাকে 2 দিন পুরো সম্পূর্ণ রাত 8টা থেকে একদম সকাল 3টে পর্যন্ত আমাকে পুরো পিটাই করেছে স্যার।
আপনাকে
আর
কি দিয়ে মেরেছে? কি দিয়ে মেরেছে? চর্চা
স্যার,
করবে
না না স্যার, বেতের লাঠি দিয়ে মেরেছে। আর স্যার মানে লাঠি চড় স্যার সব যে যেরকম পেয়েছে সেরকম মেরেছে স্যার আমাকে। ফুটবলের মতো স্যার খেলেছে আমাকে থানার মধ্যে স্যার। আর এসে তো স্যার মদ মানে সারাপ পিয়েছে, মানে মদ খেয়েছিল স্যার।
হ্যাঁ, এখন ব্যাপারটা হচ্ছে যে আপনাকে যে মারধর করেছে তার জন্য তো ডকুমেন্ট চাই। ডকুমেন্ট গুলো
হ্যাঁ স্যার,
ডকুমেন্ট
আমি তো স্যার সিসিটিভি প্রোটেক্টের জন্য স্যার একটা মানে দিয়েছিলাম স্যার। তো আমাকে এখনো সিসিটিভি প্রোটেক্টের ওই ডেটের এখনো আমাকে কোনো দেয়নি স্যার। আমি তো ওটা স্যার মানে দরখাস্ত করেছিলাম স্যার। আর আমাকে নিয়ে যাওয়ার সময় স্যার কোনো না, তার আগে কোনো আমাকে না নোটিশ টুটিশ কোনো জারি করেনি স্যার। আমাকে তো স্যার একটা নোটিশ দিতে হবে না স্যার, যে আপনার এইখানে এরকম হয়েছে কি আপনি ইনলিগেল কি লিগেল। স্যার আমি তো আমার সারা ডকুমেন্টস তো স্যার আমাকে ভেরিফাই আমি করেছি স্যার, তবুও স্যার এরা তো শুনিনি স্যার, আমাকে নিয়ে যায় জোর জবরদস্ত করে স্যার, পুরো ফ্যামিলি টর্চার, ফির গালি গালাজ স্যার, এরকম কানুন বলে তো একটা জিজ আছে না স্যার।
However, learned PP requested me to take passover in this matter, his permit.
Which PP?
Mr. Sumit Karmakar.
Oh,
স্যার এক পুলিশ কনস্টেবল স্যার লেডিসের সামনে স্যার আমার পুরো কাপড় খুলে দিয়ে স্যার, আমি মুসলিম না হিন্দু স্যার, এটা তো কোনো মেডিকেলের কোনো একটা আছে না স্যার, যে আমি মুসলিম কি না এটা মেডিকেলে লিখে থেকে করার দরকার ছিল না স্যার। ওরা নিজেরা স্যার সবকিছু করলে স্যার ঠিক আছে স্যার, আমি স্যার ইনলিগাল ঠিক আছে, আমাকে তো একটু টাইম দেবে না স্যার, আমি যে আপনার মানে সার্টিফিকেট গুলো পেশ করার জন্য। স্যার কোনো কিছু সার্টিফিকেট নিয়ে গেছি স্যার, আমাকে সার্টিফিকেট দেখেনি, আমার মোবাইল কেড়ে নিয়েছে, আমার ঘরের সাথে কোনো সাক্ষাৎ করতে দেয়নি, রাত ভরে স্যার ওইভাবে আমাকে পিটিয়েছে স্যার, খালি মানে কাপড়টা খুলে দিয়েছে।
just a minute. Key, whether all the service has been taking place. Service, না সেটা ঠিক আছে, সার্ভিস
Service has taken place.
okay, now the serious allegation against the police officers.
That man, learned PP has to stand.
না এটা আমি এটা সিরিয়াসলি নিয়েছি, ওর কথা কেউ শুনছে না, ইভেন যে লয়ারকে দেওয়া হয়েছে লিগ্যাল সার্ভিস অথরিটি, তিনি বলছেন যে আমি তোমার কেস করব না, আমি তোমার কেস করব না, মিথ্যে কথা বলেছো। হোয়াট ইজ হিজ নেম?
হ্যাঁ স্যার।
কি নাম উকিল বাবুর নাম কি?
আনজার আলী স্যার, আমাকে মানে বলেছে যে আপনার কেসে কোনো এ নেই, আপনি ফলস এলিগেশন লাগাচ্ছেন, আমি আপনার কেস নেব না। উকিল বাবু যদি এরকম বলে স্যার, তাহলে আমি কি করব স্যার? আপনি বলেন স্যার।
জাস্ট এ মিনিট, আপনি যখন আপনাকে পার্সোনালি এনগেজ করতে পারেন বলতে পারেন, কিন্তু যখন মেম্বার সেক্রেটারি আপনাকে অ্যাপয়েন্টমেন্ট করছেন আপনি বলতে পারেন না আমি নেবো না কেস, তুমি মিথ্যে কথা বলছো। He should be removed from panel.
Those things should be answered by Jain.
I have called him Ansar Ali or whatever meet. Why is Mr. Amjad Ali? It is very serious issue. Please, Mr. Dwivedi, just
definitely.
try to understand. You are the Indian citizen. If anybody,
স্যার
just a minute, if anybody
Yes, sir.
and say that you are not in Indian, it is a very much insult to my conscience. আমি ভারতীয়, আমাকে এইরকম বলছে, এটা গালাগালির থেকেও সমান, তাই তো মিস্টার হালদার? হ্যাঁ, আর সেখানে ওকে জোর করে অ্যালিগেশনটা যে জোর করে ওকে মারধর করা হচ্ছে, ওকে বলা হচ্ছে তুমি স্বীকার করো তুমি বাংলাদেশ।
মুসলিম
আমি কি আস্তে আস্তে আমি আপনার
আচ্ছা।
কথা
সরি স্যার।
আপনাকে কেউ
Sorry, sir.
কিভাবে বলেনি, তো এইটা আমি আমার সেন্টিমেন্টে লাগছে। একজন ভারতীয়কে যদি কেউ বলে যে তুমি বাংলাদেশি হিসেবে স্বীকার করার, এখানে ও সমস্ত সার্টিফিকেট দেখাচ্ছে, এবং তা না ওকে অত্যাচার করেছে, এটা বলতেই পারে, এটা ভীষণভাবে এটা অপমানিত হতেই পারে। হ্যাঁ, সেক্ষেত্রে এটাকে আমি ওইভাবে ছাড়তে পারি না। হ্যাঁ, এটা আর যিনি এই মেম্বার সেক্রেটারি যাকে অ্যাপয়েন্টমেন্ট করলেন, তিনি তাকে রিফিউজ করতে পারেন না, তুমি মিথ্যে কথা বলেছো আমি তোমার কেস লড়বো না। এটা আপনি আপনার পার্সোনাল হিসেবে, আপনি যখন পার্সোনালি কেউ আপনার চেম্বারে আসবে আপনি বলতে পারেন, কিন্তু আমরা আপনাকে এনগেজ করেছি, আপনি বলতে পারেন না। আমার তো মনে হয় তাই, আমি তাই বুঝলাম। মানে অমিত বাবু বলছেন যে উনি এরকম বলেছেন, আমি সেটা রেকর্ডও করেছি, ওনাকে আমি ডেকেও ছিলাম কিন্তু পেলাম না। যাই হোক, আনফর্চুনেটলি সুমিত বাবু আসতে পারছেন না। আপনার কথা আমি শুনছি, চেষ্টা করছি। আমাদের তো পিরিয়ডটা তো খুব লিমিটেড, সুতরাং ঠিক আছে, আমি নেক্সট কেস করছি, সুমিত বাবু আসুক, আবার আপনার কেস নেবো নেক্সট। পাসওয়ার্ড করে রাখুন, ওই একটা ওদের ম্যাটার আছে, দেখবি কখন হবে ওটা। এই আবার লিস্টে চলে গেল, লিস্টে চলে গেছে। কি আছে এটা? 16 নেই, নট টুডে কেউ তো নেই।
It's not only that he will appear through virtual means.
Yes, no problem. Yes,
It is a case, my lord, I have applied for.
so you have to show that you are the, one of the co-sharers of that,
My lord,
why is that document?
my lord. The registered will.
Why,
Is that
if probate is not required here,
probate is not.
but is there any objection against such will?
No,
There's no such.
so they are also the beneficiary.
Here also be beneficiaries.
Okay, so,
And the land is under joint occupation.
okay.
My grandfather who executed the will, the land was.
I am appearing for the respondent authority, Lordship.
Yes, yes, just a minute.
My grandfather during
Lordship.
executed a registered deed of will.
Yes.
We are the beneficiary. I myself, my brother who is the respondent number 4, and the respondent 3 who is my father. Now, there is a dispute arises in respect to some other land property which is outside in some other places, in the same place, other places. Dispute arises, my father, I am in occupation there, I am residing there, along with my family. My father, I have not received the summons, but I have been told that my father filed a suit for eviction.
Against
That is
whom?
against me. Against me.
Against you?
Yes,
Eviction suit
eviction suit.
from another property,
Another property.
not from this property.
No, not from this property. After the execution of this deed of will, my grandfather during lifetime given the possession. I am in possession by share.
It's agricultural land.
It is agricultural land. So I am engaged in dairy farming business.
Oh.
So I am having the cows. I have constructed.
Business, you have business.
Yes.
Dairy farming.
Yes.
So is the license?
But I have.
Nothing is required. Probate is not required.
License being not required.
And court fees is also not required, only 20 is required.
Lordship, can I pray that let me file the opposition, Lordship?
Yes.
Let me
That,
file the opposition because this case is not like simpliciter of granting of electricity connection.
started counsel for the respondent number 1 and 2 has appeared and submitted that he wants to file affidavit in opposition. Stop. Para. Let affidavit in opposition by the respondent numbers 1 and 2 be filed within 2 weeks from date.
3 weeks may be granted, Lordship, because circuit is in the June.
3 weeks from date, and affidavit in reply, if any,
1 week.
by 1 week thereafter. This the matter before the next step.
Next circuit bench, Lordship, in the month of June. Obliged, Lordship.
18. Who passed this order? Contempt proceeding. Why is the petitioner? এটা লিখে নিন. This order was passed by Honorable Justice Supratim Bhattacharya and this contempt application has been filed on the plea that the order passed by Honorable Justice Supratim Bhattacharya has not been complied with. Stop. Para. Registry is requested to place the instant matter before the Honorable Justice Supratim Bhattacharya in accordance with law. In accordance with law, লিখতে হবে।
Substitute service.
So he is not appearing.
Respondent number 2 and 3.
So have you taken steps to serve upon them?
Process server of this court went and submitted his report that their office was found blocked.
So where is your petition?
Can number 1 of 25.
এই ক্যান নাম্বারটা কোথায়? 1 of 25. Yes, page. The learned counsel for the petitioner has submitted that the respondent number
2 and 3.
2 and 3. No. Submitted that the service upon the respondent numbers 2 and 3 could not be effected. And as per report of the process server, the office of the respondent numbers 2 and 3 is was closed. And as such, he has prayed for permission for substituted service of summons upon the respondent numbers 2 and 3. So paper publication, it will
The Daily Telegram. Right?
Sure. Accordingly, the petitioner is granted liberty to make the paper publication of gist of summons or something like that.
Notice of appeal.
Notice of appeal. Paper publication concerning notice of appeal to be published. না এইভাবে লিখতে হবে না। The petitioner is given liberty to publish a gist of notice concerning the present appeal in the daily newspaper, namely
The Daily Telegram.
circulating in Andaman and Nicobar Islands. In accordance with the relevant in accordance with law. So you have to give draft or something like
Yes, I should submit the draft for the minister.
the petitioner is to submit relevant draft to the concerned registry personnel for approval. So this is the matter in the available and next available circuit. Oh, and respondent numbers two, you are,
I have for 1.
the respondent number 1 is represented.
Can is disclosed.
The can number 1 stands disclosed.
Next one.
Huh?
Yes, sir.
Next, sir. Yes. কত 20?
Responded not. But
Yes,
I'm saying a negative next reduction because the council is asking to say it's suffering from the throat infection. He is unable to actually
Food infection.
throat
infection.
infection.
So you have for
I have for the petition, let it go to next circuit because before the court was started in the 24th April.
the learned counsel for the respondent has sought for an accommodation as her senior counsel is indisposed of. Place the matter before the next circuit. Okay.
21, we have 27 and 26.
21, my lord, I have failed for the accused persons.
And also, item by the appears to the petitioner. I pray this matter for next circuit.
Why?
It's not very often.
Who is your senior?
Rakesh Pandey.
Huh?
Rakesh Pandey.
Apistol Green. So he appeared yesterday.
Yes.
Okay. So next circuit. The learned counsel for the petitioner has sought for accommodation, and she has requested to place the matter before the next available circuit. Accordingly, the prayer is allowed. Is the matter before the available next circuit. Next available circuit.
According to the respondent, the appellant's counsel is not well, not because he has.
Not today.
Yes.
Not today, not today. Next.
During the pendency of the appeal, the respondent number 3 was expired. In terms of the earlier order, I filed an application for suspension of the legal error of the respondent number 3. It has to be allowed and.
Your
My senior is appealing to 1, 2, 3, 1, 2, 4, 5.
So are you ready?
It's already allowed as parts and necessary steps has to be initiated to substitution.
So have you filed any
Yes,
application?
my lord, I filed. Can do as the
ওই ক্যান টুটা কোথায়? ক্যান টু কই? ক্যান টুটা দিন। দেখতে পাচ্ছি না। ক্যান টু কই? আচ্ছা, কত আগে একটা এর হচ্ছিল না, আগে যেটা আগে প্রথম এলো লিস্টটা কোথায় গেল? Just a minute. পাসওয়ার্ডটা বুঝছেন? যেটা অনলাইনটা অ্যাপিয়ার করছিল এইটা পাসওয়ার্ড করলেন তো? নিউ মোশন এইটা হ্যাঁ, এই 11টা এটা ভাবিয়ে দেবেন নিচে নিচে দেবো, নিচে দেবো। হ্যাঁ, 11 yes can 2
yes, my lord. Can do not para number 2. They have furnished the details of the legal error of respondent number 3. Even the reform under has been substituted.
আচ্ছা লিখে নিন। The learned counsel for the petitioner has submitted that the respondent number 3 Pushpa Mondal died.
Number 2 is Gautam Mandal. Respondent number 3.
Respondent number 3 Gautam Mondal
Gautam Mandal
died.
His
Died.
wife has to be substituted. Gautam Mandal.
Died, leaving behind Pushpa Mondal is her only legal heir.
That is the only legal error they have furnished.
Is only legal heir as per report of the other respondents.
But as is legal here, my lord, only one or we can't ascertain whether they have fixed.
No, actually,
They have
their
furnished the
submission.
They have
details.
furnished the details.
As per their submission.
Yes.
Stop. As per report submitted by the, as reported by the other respondents. ঠিক আছে? Stop. Para. Let the legal heir of deceased Gautam Mondal. Now, why is the certificate, their date of death certificate
But we have not furnished. Earlier occasions.
submitted? দেখতে হবে কিন্তু ডেথ সার্টিফিকেট গুরুপদ মন্ডল। You please check then, then you type. আপনার চেক এটা দেখে নিন। নাহলে মারা যায়নি তারপর দেখা যাবে। কি বলবো লেট। Why is the death certificate of Gautam Mondal? Ask them to show. হ্যাঁ, ওদের একটু দেখাতে বলি। ওকে বলুন।
But I will ask.
Yes, please assist. late, namely, Pushpa Mondal, be substituted in place and state of Gautam Mondal in the cause title of the instant. The writ application, the writ petition.
Against the MSC.
In the cause title of the appeal. Stop. The petition is to take appropriate steps accordingly. This is the matter in the available next set. You check,
This is.
otherwise this order will not be given effect. Call other.
24.
Yes, why is the respondents?
Since the beginning, your worship is working on and nobody's appeared.
What can be done, madam? Ask you,
Let it be in the next certificate, let it be recorded and appears.
none appears on behalf of the respondents. Stop. The learned counsel for the appellant has submitted that let the matter be placed before the available, next available time.
Not let it be in the next certificate, it is not my submission.
Okay.
Difficult.
So, please delete this portion. As the respondent is not appearing, let the matter be placed before the next circuit. Next available circuit bench. Okay.
Your worship, this matter was actually fixed tomorrow, but.
Hey, it can
I
be-
have asked, instead for day after tomorrow,
Oh,
Opposite.
okay, not today.
not today. Your worship, I am for the appellant.
Continue up your for this one. I pray for next one.
Oh. Go next slide. Go.
Hey,
Hey,
of the respondent.
on the prayer of the respondent, matter be placed before the next circuit.
27, 9 of 24.
Not today, not today.
28, 15 of 24. I am for the appellant. Even item number 27, I am for the appellant.
Same thing. Next available circuit.
27 and 28, both your worship, I am appealing, nobody is appealing for it. So none appears. Your worship.
None appears on behalf of the respondent. Let the matter be placed before the next available circuit.
27 also, 27 and 28.
27 and 28. Next circuit. Ashif,
But if I followed in the order and the counsel for the respondent are submitted because he is a family member of this previous person.
death certificate must be there.
Or it should be.
Hey, wait, legally, just change it. The learned counsel of the respondent is requested to submit a copy of death certificate of Gautam Mondal.
Because they are the legal of group of the murder.
I have directed them. I have responded. I have directed respondent.
I'm sorry.
Communicate this order to your brother. Okay, but he is not there. Okay, change. No death certificate. You have to submit. Next, রাখুন তাড়াতাড়ি।
If you want to forget.
হ্যাঁ? কোনটা?
If you want.
অর্ডার করে দিয়েছি। হ্যাঁ, next circuit. ওটা next circuit হবে। This the matter. You go to the next circuit after.
I think we find through 18 of 25.
Yes, argue. Nobody is here. Not today, not today. Okay, next. Argu.
We have not been so, as of yet, we have sought.
So how is,
Mr. Bala, the opposition, these are related actions. No, I think this matter is not been served. We might have filed an affidavit.
no, that is different issue. But have you filed any affidavit?
Because service hours are there, have they served to us? They will be serving now.
No, the few minutes only before they have seen, I have seen them. Morning I have.
In the morning, they have the We have a number, your
Check,
lordship.
check, check.
Your lordship, if I know. I just, we have to go through this to decide whether we file a reply or not, but even if we decide to file a reply, I want to clear this with your lordship, obviously. If there is any time, I understand your lordship, tomorrow, at any time, if it could be the top of the list, I want to make it rest for an interim order.
Okay.
In the meantime, and I base my case to that effect only, because I might have, because that may be so, you
Okay.
may decide.
So
That your
asking
lordship may
is,
decide.
the learned counsel for the respondent numbers 2, 3, just 6 and 7 has filed affidavit in opposition. Stop. The learned counsel for the petitioner
Yes. Just receive the copies.
has submitted that he has just received the copy
In presence.
in this court. Copy of the affidavit in opposition in this court. However, stop. Please, however, delete however. Please the matter tomorrow. Yes, fairly at the top.
Yes.
মাঝামাঝি রেখে দিন ঠিক আছে
But it is an appealable order.
whatever is going to they will take objection no problem.
No, this matter on the last occasion, they had similarly situation arisen, they had preferred an appeal.
Your lordship.
Even in this time, they have chosen not to file an appeal, my lord.
Your lordship, if I may.
Come back tomorrow. Okay.
No, I am the main respondent in the Palan, I am only.
Okay, please come. কালকে এটা হবে টপে না একটু নিচে মাঝামাঝি রাখবে হয়ে গেছে ডাকো ডাকো only one.
Lordship, I have filed the affidavit of silence.
Oh.
After the fifth,
So not today. Come tomorrow. হ্যাঁ হ্যাঁ 5টা মিনিটটা কি হয়েছে হয় ইজ মিস্টার সুমিত কর্মকার এই হোয়াট হ্যাপেন্ড এটা হ্যাঁ what happened it's a serious allegation against this
All are baseless allegations, fabricated.
no
Can be decided.
no what is the problem Amit Kumar Vishwas he has stated that he has been mercilessly beaten up
Supporting document.
he has submitted documents
I did not get it.
এই আচ্ছা সুমিত বাবু এই যে সরকারি উকিল বাবু আপনি যে ডকুমেন্টস গুলো দিয়েছেন না উনি
জি স্যার
ওনার কপিটা ওনাকে দেয়া হয়নি উনি এইটা না দেখে কিছু বলতে পারছেন না উনি আজকে দেখবেন সময় চাইছেন ঠিক আছে
জি স্যার হ্যাঁ ঠিক আছে
এই একটু দেখে নিন একান্ত কেন উনি দেখে নেবেন কপি দেওয়ার দরকার নেই দেখে নিই কালকে আমি শুনবো ঠিক আছে ওকে টুমরো না ডাকো Okay.
Sorry, wait, Lordship.
Huh?
I also take some instruction from the SHO concern also.
কি করবো কি করবো বলুন এটা খুব আমার খুব গায়ে লাগছে একজন ইন্ডিয়ান যে কোনো ইন্ডিয়ানকে যদি কেউ বলে আপনি বাংলাদেশি এই ওই সেটা তো একটা প্রবলেম ঠিক আছে নিশ্চয়ই পুলিশ সন্দেহ করতে পারে
Lordship,
পুলিশের সন্দেহ করার অধিকার আছে
Lordship, kindly allow me to submit.
না don't say anything against
Against him, I am not against him.
Huh.
Lordship, in this island, many foreigners, Bangladeshi, building.
maybe I have said on that day police has legal right to raise suspicion
Second
but
point,
that does not mean that you can torture
Lordship, it doesn't
Huh?
mean that only oral submission, baseless submission, all
And the
persons
poor,
are
just
blaming
see
police.
the poor person but he's
Lordship, all
he's-
persons are blaming police. Why he was called?
but
What
why
is the information?
why he has mercilessly
Lordship,
beaten up
Dismiss court found, revision.
lawyer is not taking brief yeah some lawyer
That
some
is-
lawyers not.
That is different aspect.
You please go through and come back
I will go through the entire report also.
now there is a medical report
Lordship, I have to go through.
the
I have to
poor
take
person
some
why
steps.
he will raise false allegation against the administration he is a poor person ও খুব গরিব মানুষ ও কেন পুরো এর বিরুদ্ধে কেন বলবে বলুন তো ওর কি ক্ষমতা আছে
Your Lordship, before a police
না না
doing interrogation, Lordship.
just consider his sentiment he is an Indian
Removing cross, it is possible in the police station.
mercilessly beaten he is
Next, Lordship, it is possible.
okay come back কাল আসুন হ্যাঁ কালকে
On
অমিত
Friday,
বাবু
on Friday.
হ্যাঁ স্যার
Some person-
আচ্ছা আচ্ছা ফ্রাইডে আসছেন উনি আজকে দেখে পরশুদিন বলবেন হ্যাঁ পরশুদিন
হ্যাঁ ঠিক আছে
ঠিক
ঠিক
আছে
আছে স্যার থ্যাংক ইউ থ্যাংক ইউ স্যার।
Can people go through the file, that file?
yes.
File.
Go through it.
Yes.
এটা আপনারাও দেখার দরকার যে একজন ভারতীয় নাগরিককে কেন হবে, তাই যে কাউকে বললেই তার গায়ে লাগবে। ঠিক আছে, ওকে।